Warm greetings everyone. I'm Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Our today's topic of discussion is maintenance under Christian law. The present module will help the learner to understand about the introduction regarding the subject matter, then meaning, basis and objective of maintenance, Christian personal law as well as maintenance under Christian law. Then maintenance of wife, alimony pendant light, permanent alimony. Then we will also learn about the quantum of maintenance, alteration of the amount of maintenance, payment of alimony to the wife or to her trustee. Also, we will discuss maintenance of children and parents, maintenance under the Code of Criminal Procedure, maintenance under the Code of Civil Procedure, and finally the conclusion. Now let's begin with the introductory part. In India, the concept of maintenance is regulated by both section 125 of CRPC as well as the personal laws of different communities. Compared to the personal laws of the parties which are related to the religion of the concerned parties, section 125 of the CRPC applies to all Indian citizens regardless of their religion. A Christian woman may seek remedy under the appropriate sections of the Indian Divorce Act 1869, but a Hindu wife may do so under the terms of Hindu Adoptions and Maintenance Act 1956. In the present module, the concept of maintenance under Christian law will be discussed. Let's begin with meaning, basis and objective of maintenance. Maintenance means provisions for basic necessities of a person, including food, clothes, shelter, medical and educational expenses. Its main objective is to support or to sustain a person who is unable to maintain himself or herself due to lack of sufficient means. It is pertinent to note that the term maintenance is not defined in any personal law, but the relief of maintenance is available in almost all the personal laws prevalent in India. The concept of maintenance is intended to fulfill a social purpose. It is worthwhile to note that the idea of social justice can also be found in the preamble as well as Article 21 of the Constitution. These provisions seek to ensure that the neglected wife and children are not left destitute and starved. Therefore, the Indian Parliament, in its desire to find a solution to this problem, evolved a procedure that has found expression in Chapter 9 of CRPC. The basis of the concept of maintenance can be further be found in Article 15, Clause 3, reinforced by Article 39 of the Constitution of India. It is also important to note that Article 15, Clause 3 empowers the Indian state to make special laws for the welfare of women and children. Further, Article 39 of the Constitution states that the state shall in particular direct its policies towards securing that the citizens, men and women equally, have the right to an adequate means of livelihood, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and also against moral and material abandonment. My dear learners, let's begin with discussion on Christian personal law. Christianity is India's third largest religion, following Hinduism and Islam. Christianity is believed to have come to India during the two main periods: the first century missionary activity of Thomas, the disciple of Jesus, and the Western missionary activities from 1500 to 1975. Before the arrival of Westerners, the Christians in India were following the customs and traditions of the local Hindus. Later, when Syrian Christians came, They brought with them biblical laws, but gradually they too started adopting the local Hindu customs and practices of the native Christians. The Indian Christian Marriage Act 1872 defines the term Christian as a person professing the Christian religion. Under the Act, the term Indian Christian includes Christian descendants of native Indians converted to Christianity as well as the new converts. It extends to whole of India except the territories which immediately before the 1st November 1956 were the states of Travancore, Cochin, Manipur and Jammu and Kashmir. Christians are found all across India and in all walks of life. Most Christians in India are Catholics of the Latin Church. The state of Kerala is the home to the St. Thomas Christian community, an ancient body of Christians who are now divided into several different churches and traditions. Christian personal law or family law consists of adoption, divorce, guardianship, marriage, and succession. Christian personal law is not applicable in the state of Goa. From the earliest days of British rule in India, the quest to establish a universal body of law conflicted with other legal principles which upheld differences of religion as well as race. It was the historical role of Indian Christians to occasion legal dilemmas regarding the jurisdiction of British and native law, and concurrently about the identity of people subject to those different laws. The Indian Christian personal law was an unintended byproduct of this process, a finding which throws light both on the dynamics of colonial legislation and on the essentially modern nature of Indian personal laws. Dear learners, let's begin with the relevant provisions relating to maintenance under Christian law. The Christian marriages in India are governed by the Indian Christian Marriage Act 1872, while divorce between Christian parties is governed by the Indian Divorce Act 1869. It is pertinent to note that the Indian Christian Marriage Act 1872 fails to cover the relief of maintenance. However, Section 36 to 38 of the Indian Divorce Act 1869 deals with the alimony pendent right as well as the permanent alimony. Further, Christian wives or children or old-aged parents are entitled to claim maintenance under Section 125 of the CRPC. Thus, Christian parties can claim maintenance under following laws. Firstly, Section 36, 37, 38 of the Indian Divorce Act, then Section 125 of the CRPC and also Section 9 of CPC. Let's begin discussion of the relevant provisions relating to the maintenance of Christian wives. The Indian Christians have no personal laws and their domestic obligations have to be governed by the English law, where a wife has no right of suing her husband for maintenance. Regarding the common law of scheme of property which lasted up to 1870, it is substantially true to say that marriage transferred the property of the wife to her husband. As such, the husband could say, "What is yours is mine, and what's mine is mine only." This didn't stop here. The unity principle deprived the wife to initiate any legal action against her husband. The common law court, though gave the destitute wife an effective remedy, yet they never made a decree to compel a husband to pay separate maintenance to his wife. In the post-World War period, not only new concepts were put on the float, but emphasis was placed on reconstruction of the society as well. Provisions for maintenance under the Christian law are contained in the Indian Divorce Act 1869 as amended in the year 2001. Under Section 36 of the Act, which is only applicable to those persons who practice the Christian religion. It governs maintenance right of a Christian wife. As discussed earlier, a Christian woman can claim maintenance from her spouse through criminal proceedings or civil proceedings. Interested parties may pursue both criminal and civil proceedings simultaneously, as there is no legal bar to it. In criminal proceedings, the religion of the parties doesn't matter, unlike in civil proceedings. Now, what is alimony pendent light? Firstly, Section 36 of the Divorce Act 1869 provides that if any suit is filed under the Act by either of the parties to the marriage, that is, husband and wife both are included, the wife is entitled to file a petition for expenses of the proceedings as well as for the alimony pending the suit. It is also known as interim maintenance. From the perusal of the provisions of Section 36, one thing is clear, that only a wife and not a husband is entitled to claim maintenance under Christian law. Section 36 of the Indian Divorce Act is similar to Section 24 of Hindu Marriage Act. However, Section 36 of the Indian Divorce Act differs in the respect that maintenance pendent light and the interim maintenance can only be claimed by the wife and not by the husband. Now, let's discuss about the provisions relating to permanent alimony. Section 37 of the Indian Divorce Act provides that where a decree of dissolution of marriage or a decree of judicial separation is obtained by the wife, the district court may order that the husband shall, to the satisfaction of the court, secure to the wife reasonable lump sum money or such annual sum of money for any term not exceeding her own life. It is further provided that for the purpose of securing the payment of alimony, the court may cause a proper instrument to be executed by all necessary parties. Now, what will be the quantum of maintenance under Christian law? While fixing the amount of maintenance, the court may consider following factors. First of all, the financial ability of the husband. Secondly, personal fortune of wife, if any. Also, the conduct of the parties is a relevant factor. Whether once the maintenance is fixed, can it be altered in future? The answer is yes. The Act provides that the amount of maintenance may be altered in future in case the husband, due to any reason, becomes unable to pay such amount. Thus, such amount can be increased, decreased, or even suspended for a particular time period. Now, there is another important provision relating to payment of alimony to wife or to her trustee. Section 38 of the Indian Divorce Act lays down that in all cases in which the court shall make any decree or order for alimony, it may direct the same to be paid either to the wife herself or to any trustee on her behalf, to be approved by the court. The court is also empowered to further impose any terms or restrictions to which the court finds expedient. The court may also from time to time appoint a new trustee if for any reason it shall appear to the court expedient to do so. It is important to note that the provisions of Section 38 of the Act are quite similar to those provided in Section 41 of the Parsi Marriage and Divorce Act 1936. However, under Section 41 of the Parsi Marriage and Divorce Act 1936 also includes the provision of making such payment to the guardian appointed by the court. It is also evident that the provisions of Christian law relating to maintenance are similar to those under the Parsi law, and The same considerations are applied in granting maintenance, both alimony pendant light as well as the permanent maintenance. Let's discuss about the maintenance of children and parents under the Christian law. My dear learners, as regard Christians, there is, like Parsis, no separate law relating to maintenance of children or aged parents. Section 41 of the Indian Divorce Act 1869 provides that in any suit for obtaining a judicial separation, the court may from time to time, before making its decree, make such interim orders and also may make such provision in the decree itself as it deems proper with the respect to the custody, maintenance and education of the minor children. It is further provided that the application with respect to the maintenance and education of the minor children pending the suit shall, as far as possible, be disposed of within 60 days from the date of service of notice on the respondent. Similar powers are vested in the courts dealing with suits for dissolution of marriages or for nullity of marriages under the provisions of Indian Divorce Act 1869. My dear learners, it is pertinent to note that the Muslim law and the modern Hindu law, which is applicable to Sikhs, Jains, Buddhists, both are quite comprehensive in regard to maintenance of children. The statutory laws applicable to Christians and Parsis deal only with the maintenance of children of those parents who seek any of the matrimonial remedies in a very brief manner. However, the provisions of the CRPC are applicable to all the Indians alike. The religious as well as the non-religious laws in this field suffer from some flaws, and it is high time to bring comprehensive changes to personal laws to ensure that maintenance of children is ensured uniformly. Let's discuss briefly the provisions of maintenance under Section 125 of CRPC. Section 125 of CRPC provides that if any person having sufficient means neglects or refuses to maintain his child unable to maintain itself, a magistrate of first class may, upon proof of such neglect of refusal, order such person to make a monthly allowance for its maintenance. The provision applies equally to legitimate as well as the illegitimate children, and also both to male and female children, whether married or unmarried. Section 125 to 128 prescribes a self-contained speedy procedure for compelling a person to maintain his wife, children and aged parents. The right of a wife and children to be maintained by the husband and by the father is a statutory right created by the code, and it is not dependent upon the personal law of the parties. In Divyanand versus Jayarai, two Roman Catholics entered into Swayam form of marriage and lived together as husband and wife for a period of 5 months only, in the course of which the wife conceived a child. The court rejected the petition of the women as she was not a legally wedded wife. The court held that being Christian, their marriage in accordance to Hindu customs without any conversion was void ab initio, and hence the woman was not a wife in the eyes of law. As such, the women couldn't claim maintenance under Section 125 of CRPC, although her illegitimate children were entitled to maintenance under the same section. What is the relevant provision relating to maintenance under the CPC? In MV Elizabeth versus Harvan Investment and Trading Private Limited case, the Supreme Court of India observed that where a statute is silent and judicial intervention is required, courts strive to redress grievances according to what is perceived to be principles of justice, equity and good conscience. Another key case is K. Kumar versus Leena of 2009. In the context of Christian parties, K. Kumar versus Leena is a significant judgment. The issue involved in the case was whether a Christian wife and children can invoke the provisions of Section 9 of CPC to claim maintenance, even though the Christian Marriage Act 1872 makes no such provision. The first plaintiff and the defendant were Christians and were married on 27th of April 1977 as per the custom of their community. They led a happy marital life for some time and they have three issues. The plaintiffs number 2 and 3 were the son and the daughter. Later, there were differences amongst the husband and the wife. The defendant husband was addicted to bad habits and developed illicit relationships with other women. He started consuming liquor and was subjecting the plaintiff wife by cruelty and harassment by assaulting her. On an occasion in the year 1990, the defendant husband caused an assault on the wife and she sustained a fracture of her hand and was treated in the hospital. To maintain a good relationship with the defendant husband, she didn't disclose about the assault to anyone. Afraid of the cruel conduct of the defendant husband, she left him and started residing separately with her children, that is, plaintiff number 2 and 3. She was doing coolie work, but the earnings were not sufficient for the maintenance. So, she filed a petition for payment of maintenance, whereby the defendant gave an amount of rupees 3,000 and also assured to pay the same in future. Therefore, she withdrew the petition, but later the defendant husband discontinued the payment. The wife filed the present suit claiming maintenance on the ground that her husband, the defendant, is getting a salary of rupees 14,000 per month. He had the capacity to maintain the plaintiff wife as well as the children, and she sought maintenance of rupees 4,000 to herself and her children. The defendant husband contended that plaintiff number 1 has illicit relationship with her own brother, and it is because of the said reason she has been residing with him and has deserted him. He also contended that in the Christian community, the marriage is a contract, and when there is a breach by the first plaintiff, the contract stands terminated and there is no liability on his part to pay any maintenance to the plaintiff wife. He also claims that there is no provision under any law applicable to the persons of Christian community to pay the maintenance, and in the circumstances sought for the dismissal of the suit. The trial court, on appreciation of the material on record, held that there was refusal and neglect on the part of husband, and despite the fact that there is no provision in law for Christian community to pay the maintenance, held that in common law the plaintiff wife can claim the maintenance, and considering the salary of the defendant and the requirements of the children and the wife, granted maintenance of rupees 1,500 each to the wife and the third plaintiff, that is the daughter. Aggrieved by the judgment and decree, the defendant husband filed an appeal, whereby the lower appellate court as well as the higher court held that there is no illegality in the judgment. An order of the trial court was confirmed. Aggrieved by the concurrent findings, the defendant approached the Karnataka High Court in appeal. The court held that there is an obligation of part of the husband to maintain his wife and children, and in case of breach of this obligation, the wife and the children have a pre-existing right to claim the maintenance from the husband or the father. That could be enforced by the courts also by entertaining a suit under the provisions of Section 9 of CPC. The court further held that even though the Christian Marriage Act makes no such provision for maintenance, such right is available under the common law. Wife and children are dependents, and a suit by a Christian wife and children is not barred under the provisions of the CPC. My dear learners, from the foregoing discussion, it is quite evident that maintenance plays an extremely important part in matrimonial matters. This has been even more relevant in today's times when people undergoing divorces, especially who are financially dependent on their spouses, have to run from pillar to post in order to make both ends meet. Therefore, the matrimonial courts in the country hold a position of great responsibility of granting the relief of maintenance to aggrieved spouses. The Christian law also contains adequate remedies and provisions to women for their right to maintenance. With this, we come to the end of today's lecture. Thank you very much.